This is the plaintiff, Albert Shimon. He says he went to the defendant's place of business to purchase a commercial mixer for a bakery, and the guy sold him a dud machine. He wasted $600 trying to repair it, couldn't, and is now seeking the return of his money. This is the defendant, Albert Katayev. He says the plaintiff brought his own technician in to repair the mixer, and for some reason the guy never fixed it. The plaintiff never gave him $600 to repair the mixer. He gave it to the technician. So how's the plaintiff coming after him for the money today? He's accused of cooking up a lawsuit.
All parties, please use your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff bought a commercial mixer for his bakery from the defendant, and it was a stinker. It didn't work. But the defendant says the plaintiff's going after the wrong guy. It's the case of Mixer. He hardly knew her.
Thank you, Doug.
You're welcome.
Okay, so you were going to you were the landlord renting to a bakery that was going to open up on your premises.
Correct.
And you were supposed to supply a mixer to the bakery?
A mixer.
Okay, and now what kind of mixer are we talking about? We're not talking about the one in my house.
To mix, yeah.
Yeah.
It's a big dough mixer, 200-pound dough mixer.
Okay, and so how did you find the defendant?
He's down the block from where we are.
So, and he sells what?
Used equipment.
Okay, so had you bought things from him before?
No.
All right, but he was geographically desirable. So you walk over, and what happens?
Walked over, found the mixer. It's a large mixer. It looks very old, but he said it works very well. Everything works in it. I said, fine. We agreed on $2,500.
Did you turn it on to see if it worked?
No.
Why not?
I had to bring a mechanic to do that.
Why did you have to bring a mechanic?
Because I have no knowledge about equipment. I have no idea what I'm buying even.
Okay, I'm sorry. Did the thing work?
That mixer was purchased maybe 3-4 years ago, and it was standing in my showroom.
Okay.
And
so is there a way to turn it on to see if it turns on?
yes,
Okay, did you turn it on for him?
I tried to turn it on. It did not came on.
Okay, now hold on.
Yes.
Is that accurate?
He never put it on until the mechanic came in. I said, I have no idea what I'm buying. Put it to work in front of me, in front of the mechanics.
And you bring a mechanic, and what happens?
He said, okay, let's plug it in. See
And
if it
then what
works.
happens?
Nothing works, only one light.
And then what happens?
He says, let me check it out for a few minutes. He opened it up. He says,
He being the
all
mechanic.
Mechanic.
Okay.
All the wiring are corroded, falling apart in the machine. There's no way to start this. I'm going to have to rewire this completely first to see if it works.
Okay.
He was in front of us. We agreed on $600.
Who's we?
Me, the mechanic, and him.
Him. What does he have to do with your mechanic getting paid to inspect something to see if you want to buy it?
Not to inspect. I told him, if you want me to purchase this, we have to fix this. Otherwise, this is a dud. It doesn't work.
So,
I say, if not, I'm going to walk away. I don't want it.
right. So what was the price you guys had negotiated beforehand?
$2,500.
Okay. So then the mechanic was going to charge $600 to fix it.
To rewire it, to put it to work.
To fix it.
To rewire it, yeah.
To fix it.
Supposedly fixing it.
Okay. And then, so he was going to you were part of the agreement because
100%.
you were going to take $1,900 for the thing.
Exactly.
Okay. And then what happens?
Then what happened? The mechanic did his job, rewired the whole machine, plugging it in, nothing works. When he found out all the switches on the panel are no good, all has to be ordered from the manufacturers, and the motor itself, no good no longer. It's very, very, very old.
Okay. And so he never got $600, but your position is that was essentially a $600 deposit.
Correct.
Because he was assuming the whole cost of the repair and was deducting it from the purchase price. Did anybody foresee what might happen if that $600 didn't solve it?
Of course. Of course. That's why he put it in writing.
Let me see what you've got in writing.
Yeah.
Whose handwriting is this?
Mine.
Okay, I'm going to need you to come up here.
Do you want the original one?
No, I'm still not gonna understand your handwriting. So I want you to stand right here and read that to me. One used 2-bag mixer, 200
Yes,
pounds.
yes.
Payment for what?
For repair,
For repair.
$600.
600.
On the bar,
Model, whatever, and
Yes.
then what's that say?
I asked the technician name because he has
Jose?
Yes.
What's that say?
warranty. He want to provide 1-year warranty for his repair. And I put on the bottom, it's a customer contractor.
That says contractor?
Yeah, company. I'm sorry.
Customer company.
Yes,
30 days for motor by.
by me, by
That's
my
you.
company, yes.
His position is that by doing this, if you have a beef, go sue Jose, even though he's the guy who brought Jose in, because you adopted Jose as being able to fix this. And it's very clear from this, he says, that he was only going to buy a working mixer. Can you go ahead and go back there? Yes, I know he brings Jose.
Yes.
But the three of you worked out a deal where I don't think anybody thought Jose couldn't fix it. Everybody thought Jose's going to be able to fix it. Everybody's going to be happy. Who actually paid Jose? You did?
Yep.
Do you have proof you paid Jose?
Cash. It was cash. I went to the bank, took a $600 cash, and gave it to him.
Well, that had to have happened, though, because that was the agreement you guys had. Did Jose fix it at your place in front of you,
Oh.
or try to fix it?
He tried to fix, he brought only one contactor, which cost $30, installed it, and he said, I need the other part on-off switch, which I'll come back on next Sunday. And he never did. I am a
Okay,
technician.
so, but we have a problem. And the
Yeah.
problem is that you got involved in this deal. You got very involved in it by absorbing the cost of Jose and reducing your price by Jose, and then giving this guy a 30-day warranty on the motor, which implies that you know that if it's not a working motor, then he's not supposed to be out anything. Like, in other words, this isn't an as-is sale. You're giving him a 30-day warranty. And so after Jose couldn't fix it, did you hire somebody else who wouldn't bring a $30 part?
I am a technician myself. Your
So
Honor.
did you try to fix it?
The problem was because when you move the mixer, you have to remove the ball. It's a big, huge ball.
Did you try to fix it, yes or no?
Yes, it
Did
was.
you fix it, yes or no?
Yes.
You were able to fix it?
Yes, ma'am.
So it's working now?
Yes.
Okay, who's the fellow with you?
This is my son.
Okay,
Hi, Your Honor.
hi. And what did he just hand you?
He had me the.
He also smells like a lawyer. Is he a lawyer?
Yes.
Yeah, there we go.
It's an honor, Your Honor.
Ain't even that big.
You see that stainless steel ball?
Yeah.
To go through the door, which is mostly businesses have 36-inch door, we must remove the ball out.
Right?
And when I bring it to my store, I did not bolt it together. I did not put the hook. This is why mixers have protection for safety, and we have a micro switch on that.
Right.
After it's happened, I had the other customer. He came in and he was interested on that. So I stick my nose and I find out that micro switch for protection was open.
Why didn't you stick your nose in it when he was around and before the
I
other
have
guy
a-
and before you took 600 off?
I have two reasons, because I was busy with the other job. I didn't have time. This is why I give him, original price was $3,500. These mixers new cost over $16,000.
Right, but here's the problem, okay? I'm looking at the receipt you gave him, and it's very, very clear that you intended not to sell it as is. Hey, I gave you a good deal, tough, it's on you, like you're talking now. You intended to sell something with a warranty. That means you are agreeing this thing is gonna work. And then you agree to pay to make it work. When I say pay, to absorb the $600 in the deal in order to make it work, okay? And then it doesn't work. So here's a guy who has no mixer. You agree to absorb the price to make it work. And then he has no mixer. He's out $600. And I know you didn't actually get a deposit of $600 because instead of you getting it, He just went ahead and paid it to the guy, which you agreed for it to happen. But he's not supposed to pay it to the guy. You're supposed to pay it to the guy, according to this. So he did give you $600. He just gave it to the guy who you were going to absorb it from. You see? So, and now he doesn't have a mixer. And then it turns out it was a perfectly good mixer. Somebody just had to fix the switch. So did you end up selling it?
Yes,
What'd you sell it for?
$3,000.
Yeah, there you go. Okay. And now the guy wants his $600 back.
May I be heard, Your Honor?
You know, we don't allow lawyers to be heard in here, but
As a
I'm going to
witness.
let you
As a
be
witness.
heard, cowboy. As a witness and as his son, go ahead.
So the plaintiff bought a mixer that didn't work. I suppose you could get it repaired. Does the plaintiff have a right to get money back just because it doesn't work and not get it repaired?
Yes, he should get his money back if it doesn't work.
How come?
He paid for a working mixer.
You do, but why can't you just get it repaired?
And you could, but if you paid for a working mixer, you should be able to get a
So you could undo the deal.
Yeah.
Okay. Ma'am?
But be reasonable. It's repaired once, I would wait. But if it's more than once, yeah, I want my
But you
money
would
back.
give him a chance to repair
I
it.
would. I would.
Fair enough. Going inside the courtroom.
I serve as Secretary, Treasurer, and General Counsel to the defendant. I review all the contracts, all the legal work, anything to do with the company. And what I want to tell you as a witness in this case is that generally speaking, when any used item is sold, as the company is a licensed used secondhand dealer by the New York City Department of Consumer Affairs, we fix whatever product it is, whatever product we sell on our own as part of the price. This gentleman, from what I understand, the plaintiff, did not want that to happen. He wanted to bring in his own mechanic.
Right, then what'd your dad do?
When he asked for his mechanic to come in, he consented to that.
Your dad consented. What else did your dad do with this?
With the understanding that it is his responsibility to deal with him directly.
But that's not what your dad agreed to.
With
Look
res-
at this form. Hold on a second. What
Yes.
your dad agreed to is that your dad would absorb the entire $600 to try to get it fixed. And two, way more importantly, it'll be successful because I'm giving you a 30-day warranty. He has a deadline. He's got a tenant moving in. And then your dad's answer to why he didn't fix it. Like, in other words, if your dad tinkered with it right after that guy and was able to get it in time to him, that'd be great. But when did your dad tinker and fix it? Later. And so how on earth then could your dad, A, sell him a work? We know that your dad agreed to sell him an operable machine. Not an as-is machine, an operable machine, right? Yes or no?
I respectfully disagree, Your Honor.
How on earth, when you say 30 days for motor,
I'll explain.
how is that not a warranty?
I'll explain.
Okay,
The
you're not really a witness. You're a lawyer here, but go ahead.
The warranty is for the motor only. He testified that the wiring was the issue. And we had testimony about the contactor and the wiring.
I'm sorry. As it turns out, nothing was an issue. Your dad had disconnected something and forgot to connect it. But please tell me how it is when your dad is... Essentially what it is, yes, you guys fix it normally, and your dad made an exception in this case.
Correct.
Your dad decided that he would pay somebody to fix it. He would pay somebody to fix it. That's why it's deducted from the purchase price. Not he. See, I thought, before I saw this, I thought that guy spent $600 to get some guy to look at it, and then inappropriately was trying to get this guy to absorb it.
But that's exactly
what you want.
what's happening.
It isn't.
Because the
It
original...
isn't.
The original
because
agreement...
take a look at what your dad wrote before you got involved in the case. What he wrote was, I'm selling it to you for $2,500, but I'm gonna pay somebody. I'm gonna pay somebody $600 to fix it, and so I'm really just selling it to you for $1,900. Nobody thought that the guy couldn't fix it, and now that the guy couldn't fix it, what happens? He's right. That $600 is a deposit, and it goes back to him. But you're a good son and you tried hard, but you can't fix the stuff your dad does behind your back before talking to you about it. $600 verdict for the plaintiff.
Thank you, Your Honor.
Thank you.
Well, that was kind of fun, Mr. Katiev. You brought your son with you. He gave it the good college try. What do you think about it? What's your reaction to what the judge just said?
I disagree with the judge's decision. I thought that there was a modification of the agreement. The original agreement was for $2,500, and then he agreed to reduce it by $1,900.
Judge says you're wrong. Sorry, good try, lawyer. Okay.
Thank you.
You got to give him the $600 back.
Of course.
Okay. But anyway, you sold the machine for $3,000, so you're still okay.
Of course.
We're down
Good for
100.
you. You're down 100. Okay. Congratulations.
Thank you.
Well, not congratulations. You're the loser.
Thank you.
Okay, good luck. All right. And you are back where you were. Did you ever get a machine?
Oh, yeah.
Oh, you got one somewhere else.
4,500. Yep.
4,500, paid more. But is it working?
Yep.
That's
100%.
100%. Congratulations.
Thank you very
Okay,
much.
thank you very much. You must sign some documents. Harvey?
Okay, even if there isn't a warranty, there is something in the law called a warranty of merchantability. And usually, if somebody's in business selling products, the product has to perform the function for which it was made, intended. And if it doesn't, it violates that warranty. And those warranties are implied in every contract for a product.